Hi there, my name is Jamal Khan. I'm a senior tax partner at Churchill Tax and the Churchill Tax Group. Today's topic is going offshore and tax planning for going offshore. It's quite an interesting topic. I've had plenty of people ask me about this over the last couple of weeks, couple of months, and for the right people, there could be some significant tax savings by going offshore, but the circumstances have to be right, of course. So I'll get started. This is just a little bit about us in terms of who we are. Churchill Tax, kind of leading tax advisors in the country, and with a very strong team. And the agenda for today is going offshore. What are the benefits, the income tax benefits, the capital gains tax benefits, the inheritance tax benefits, and more importantly, the anti-avoidance legislation on what you need to watch out for. Going offshore, yes, understanding the rules, taking advice at the right time. If you do want to go offshore, taking advice before going, well before. So I would allow at least 6 months to maybe 8 months before you, or maybe, around 6 months before you go offshore. Take advice because there is HMRC guidance, there's the statutory residence test that you need to understand. There are a couple of automatic tests that are applied by HMRC. The third test, the test is the most common one, the one that we call offshore full-time employment or something similar. That will ensure that you are treated as non-resident by HMRC according to the law as it stands. There is a split year treatment as well. So you need to consider when you leave the UK and which part of your year is taxed in the tax year is taxed within the UK and which part of the is not taxed within the UK, where there are very complex rules around the split year treatment. But more important to understand which of the automatic overseas tests applies to you and how you use the statutory residence test for your benefit. The first now look at the benefits of going offshore. The income tax is quite a significant benefit for you. If you're offshore, your offshore income tax, your income that you've earned offshore is not subject to UK tax whilst you're non-resident. Just kind of go on my previous slide. There are a number of days going offshore, and I will cover this in the anti-avoidance section as well. There are a number of days that you need to be spending outside of the UK, and there are a number of days that you need to be spending minimum. If you cross a threshold of spending those days within the UK, for example, it's 90 days. If you spend more than 90 days in a tax year, you could be deemed as a resident, and that means your entire income becomes taxable in the UK. So you need to be very careful in terms of what the number of days are. When you count your number of days, keep a diary, keep a log, keep all the tickets, everything that you can to make sure that you're not seen as spending more than 90 days in the UK in any tax year. So for income tax purposes, you would look at the offshore income, which has no tax which is not taxed in the UK if you're non-resident. UK source income, so that kind of has different treatments. If you're working for an employer in the UK and you are working from, for example, offshore country, then that salary is not subject to tax in the UK or national insurance. Rental income is taxed. You tax as a non-resident landlord, which kind of has several benefits. And if you receive any dividend income in the UK, that's not subject to any tax. And if you've got any direct loan accounts, etc., that can be structured in such a way that you don't pay tax on direct loan accounts before you left the UK. So there could be quite significant income tax benefits if you depending on your circumstances. The next part to consider is capital gains tax. So offshore gains that you make are not subject to tax in the UK. If you have any gains on UK assets, then there are different treatments. So for UK real estate, yes, there are some gains. There are bigger gains on the residential. But for example, if you've got any non-property related assets, shares, etc., then there are no capital gains tax implications on that if you are not living in the UK, and that can be quite advantageous if you structure it and plan any disposals correctly and take advice. You could save. We've helped people who have saved a lot of money, a lot of income tax or capital gains tax by planning for their becoming non-resident or going offshore. Inheritance tax. So if you become non-resident, and inheritance tax on your offshore property. There's no inheritance tax on your offshore property. But if you have any UK property held personally, there is inheritance tax on that because that's UK cited asset. If you've got UK property in limited company, then you've got quite a few options to consider, depending on your circumstances, your family, what your inheritance plans are. And we could structure this in such a way that there is no inheritance tax to pay. And any other assets, for example, non-cited assets, then anything located within the UK, we would look at would be taxed in the UK. But if we structure and plan in advance, then yes, we can certainly take other assets outside the scope of the inheritance tax, depending on circumstances. There's also one very important point that a lot of people forget is you don't go out, become non-resident for a year and then come back and say, actually, that's it. No, you've got to plan it properly. There's a lot of anti-avoidance legislation, and there are very strict rules that you need to be aware of. For example, a lot of to take benefit of most of the income tax measures and capital gains tax measures, you've got to be out of the UK for at least 5 years, and you've also got to make sure that you are complying with any tax regulations in the UK. So the compliance is quite important, and also you're keeping records in terms of how much time you spent in the UK, how much time you went spent out, what are you, for example, tickets, hotels, or when you came to the UK, what did you do? And especially if you have a business in the UK, you've got to make sure you show what you did when you did come to the UK. So you're essentially keeping timesheets, etc. There's the anti-avoidance legislation can be quite daunting if you once you get to understand how HMRC, the measures that HMRC have put in place to catch people out who are trying to abuse the system. So for our purposes, it's quite important that we plan everything carefully. We discuss how when we leave the UK, we discuss when the client would come back to the UK. We would discuss what the activities would be in the UK after departure, after becoming non-resident, what activities would be outside of the UK after becoming non-resident. So there's quite a few areas that you need to be carefully read or be aware of, or discuss with your tax advisor. We've helped quite a few people. I mean, I've helped quite a few people, given them the right advice. Sometimes circumstances mean that people have to become resident or non-resident, and having the right tax advice can be quite useful in these circumstances. Excellent. Okay, so I hope you found this useful. If you've got any questions, please do get in touch, and I'll see you in the next webinar. Thank you.